Hello, YouTube. I'm Vince White. I am an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from Darnell Jenkins, who, I'll be frank, asks some of the best questions. Like, I evaluate and choose questions based on like which questions I think will help the most people. I gotta tell you, Mr. Jenkins asked, I think, far and away the best questions. Like, these questions are, every time I read them, I feel stupid. I'm like, why didn't I just answer that? Like, why didn't I make that video already? So, thank you, Mr. Jenkins. All right, all right, Vince. So that is very similar to how people said my name when I lived in Japan. Vince. I can't even. I'm not gonna say it because it's gonna sound like I'm mocking them. Um, also, Vince, would you love for you? I would love for you to share, if you haven't already, how to respond to a write-up, especially one you do not agree with. Also, how do you document bad behavior at your employer without being punished or terminated? And there's a little bit of back and forth where I say that's a great idea, and Mr. Jenkins responds, "Yes, thank you. This will be helpful." Um, they brought up write-ups that I signed, although I didn't agree with those write-ups, but the signature on the write-up could hurt your case. I definitely want to hear your thoughts on documenting bad behavior without the employer knowing and placing a target on your back. Okay, so I'm gonna answer this in the context of New York state law because there are some issues of state law that get rolled in here. So you need to check this with local counsel wherever you are. Make sure this is the right advice for where you are. But generally speaking, when you get a write up, they're going to want you to sign it. Now, they're going to want you to sign it, and they're going to say that your signature means you agree with the contents of the write up. And if you refuse to sign it, they're going to say, oh, this person's insubordinate. We had to fire them. They wouldn't. We told them to sign the write up. They wouldn't sign the write up. And what they're not really disclosing to you is that they're having you sign the write up to prove that you received it, right? They're going to later argue that you're signing the write up and that was your agreement with the contents of the write up, but that's not. They're gonna claim, if you refuse to sign it, they're gonna claim, no, I was just having so and so sign it to admit that so and so received the write up. And when they refused, I mean, that was insubordination. I had to let so and so go, right? So here's what I generally recommend people in New York State do. They sign it, and they jot underneath, my signature is to admit that I've received this document only. And then what you can do is you can produce a rebuttal, right? You can go home after you have a copy of the write up, and you go home and you look and you think about what really happened. You look at the write up and how that doesn't really match what really happened, and you just jot a couple paragraphs down. If you want, have a local attorney look at it. You don't have to. And if you can, use evidence. Use, like, listen, these 5 people witnessed this. Here's a picture of what actually happened. Here are the emails. I'm attaching the emails from what really happened. Text messages, whatever it is, whatever evidence you have, and submit the rebuttal the next day. Now, this is not foolproof. This is a best practice that I've been able to come up with in New York. There's going to be a lot of but ifs or what ifs below in the comments following this video. And we're going to try to deal with those, but we're all going to be a little limited here because I'm going to be saying things like, well, in New York, I would tell you to do this. And you're going to say, what good does that do for me? Well, I don't know. I mean, if you can run it by an attorney where you are, see if that would be something they also recommend, then that might be useful. If you can't, then I can't. I mean, it's not, I'm limited. I'm not allowed to give you advice as to state laws in most states. And I can advise you about the federal laws that pen through the EEOC in all 50 states. I'm happy to do that. That's what this channel does. But on things like this, I have to be a little bit limited because I got a little license to protect. And I'm not really looking to tangle with the Bar Association. They're so mean. I'm kidding. They're lovely, lovely people. The best people. So good. So good. They're not a group of old white men. They're not. Definitely not. And they don't mean ill to young attorneys who outperform them. I'm totally kidding. Bar associations are legitimately amazing. They protect clients from attorneys, and there are so many bad attorneys in the world. Bar associations are critical in protecting clients. I could joke around on the channel, but like, I got to take a step back for this moment and just be like, no, the bar association is very, very important. Not all bar associations are created equal. Sure, certainly met a few that I didn't particularly care for. But that being said, fundamentally, deeply, and meaningfully important to protect clients from attorneys. Attorneys are all too often predatory and horrible human beings. Disclaimer delivered. Sincerely. So, my recommendation is generally with a write-up. Sign it. Notate that you're signing it to admit you received it. And then write your rebuttal. Also, document things for yourself at home. And if you can document it in a timestamped way, I always recommend an email server from like a Gmail company, like Gmail or something like that, where there's going to be a neutral third party who doesn't care about either of you, unless your employer is Google, right? Keeping a timestamp of the email. You can even email it to yourself. You can email it to your attorney, whoever it is, but it creates a timestamped present sense impression of what actually happened. And that can be valuable come litigation as well, because it's your thoughts the night of, which are going to be fresher and more accurate generally than what you will say later on at a deposition or in testimony or anything else. So, Darnell, I appreciate you as always. I hope this video is a little short because I don't have that much I can say on a nationwide scale, but I hope this helps people. And I will check the comments down below to try to provide whatever notions I can, or I guess just nudge people to call a local attorney where that's needed. And remember, if this was helpful, like and subscribe. It helps me to help more people just like you. Everybody works. Not everybody wins.